So the Supreme Court has refused to share, the in-house committee has refused to share the report. What is the law?
So, you see, under the Sexual Harassment Act, the copy of the report has to be provided to the complainant. Now, in this case, they are providing a copy to the Chief Justice. Therefore, why should it not be provided to the complainant? They are citing that judgment of Indira Jaising, which is a pre-RTI judgment. Besides, that judgment is in the context of a third party asking for the in-house committee report. Here the complainant herself is asking for it. Therefore, and she is certainly entitled to know on what basis have her allegations not been found to be substantiated. What is it that the committee examined? What evidence did they go through? Therefore, she is certainly entitled to a copy of the report, and in case she has written to the Bobde committee to provide her with a copy of the report. In case they don't provide her a copy of the report, she can certainly challenge this in court.
The same court, in the Supreme Court?
Yes, in the Supreme Court also, yes, so or in the High Court.
Does the ICC report get put in public domain? Can it be put in the public domain, or it cannot be just like any other judgments?
No, it can certainly be given to the complainant, and if the complainant chooses to put it in the public domain, she can, because the only object of not publicizing it, etc., would be against her wishes it should not be publicized.
So, what are the options left with the complainant now?
So far as the allegation of sexual harassment is concerned, she can file a criminal complaint for which she will need the permission of the President, because under the Veeraswamy judgment, in a criminal allegation against the Chief Justice, you require the permission of the President. Otherwise, you require the permission of the Chief Justice himself. Whether the permission would be given to her in such circumstances, one can't say. But that's anyway a legal option that she has. Apart from that, she can certainly challenge the termination of her services in the High Court or in the Supreme Court. She can also challenge the Malafide FIR registered against her. She can also seek compensation for the violation of her human rights by the manner in which she was arrested and shackled, and her husband was shackled by the police. Her brother-in-law or her husband and brother-in-laws can also challenge their suspension and the termination of that brother-in-law who was appointed to the Supreme Court. All that can be done.
So she has to go back to the Supreme Court also for challenging all these?
No, she can go to the High Court also.
Okay. So last question, how is the complainant taking the entire development in the case?
No, she is very, very dejected because she felt that she had given a very detailed complaint which was backed by at least 30 pieces of documentary evidence, which included video records of the conversation with the SHO, video of her shackling, her husband's shackling, etc. But one doesn't know how the committee has dealt with all this. I mean, it's rather strange that the committee can arrive at a conclusion so quickly without apparently examining the various witnesses, without going through all this evidence that she had submitted. That's why she is saying that please give me a copy of the report, let me see on what basis you have found my allegations to be unsubstantiated.
And does she plan to file a complaint with the President for a criminal case?
That she will have to see. Can't say whether she will or not.
Sir,